Hey, good afternoon, everyone, and happy Friday. It's the middle of winter, obviously in mid-Missouri and then in Denver, in the Denver, Colorado market. On this date, it looks like this one will be active or live on the 26th of January. Andrew, holy cow, it's hard to believe we're at the end of January already.
Yeah, I mean, time is moving along, guys. It's time waits for no man. But yeah, no, we're cruising along, guys, and I think it's been a good year. I hope that any agents in other offices out there that are listening to this are having a lot of work pick up and getting busy. I know we are. I think we're getting a lot of those calls as the snow thaws after that last freeze we had here, that people are doing, a lot of prep work right now, right? So people are doing a lot of prep to get their listings ready for that, like, March, April, maybe late February launch. And I do think that buyers is a great time to be out and active right now. So if we're having a lot of busyness, so if you're an agent out there and you're wondering, hey, who do I call with my Monday, Wednesday, Thursday call plan, whatever your document is, I would say call your buyers and say, hey man, we got a pretty good window here where rates are reasonable, but we're not quite dipping low enough to where we're going to see that big rush. And maybe now's a good time for the next 30, 60 days to make a good push and try to get something under contract. And if you have people that were kind of thinking about selling last year but decided to wait with rates being high and giving away some of those concessions at closing, maybe think about, hey, let's start getting ready for, March, April, May, June. What do we have to do to prep? What projects can we knock out over the next 6, 8 weeks so we can be ready to go when the springtime rolls around? Because I do get the feeling, and you correct me if I'm wrong or back me up if I'm right, Michael, that it's going to come on us pretty quick here once we start getting into mid late February and into March. I think we're going to see that ramp happen pretty quickly.
Yeah, you're right. In fact, Friday of last week or Thursday of last week, excuse me, had a conversation with this couple who are buyers. They're currently renting, and I know that our topic today is going to be about some rules that have changed in Colorado and our understanding of it and kind of how we want to help navigate those. But we were discussing it. They're currently renting. Same deal. Starts out with they've identified their target areas. They've really got three, but they're all clumped together. They're on the west side of town. They're renting. They kind of get their notice from their landlord that things are going to start to increase, so that their particular landlord is probably doing the right thing on their part.
Mhm.
uh, that just definitely sparks the conversation. But the other piece of it is, you make a really good point, is to be competitive. I think it's important for people, if they're renting today, to start getting out and start opening some doors right away.
Mhm.
Start figuring out what you like and what you don't like. We may find your perfect home right out of the gate, but it may take us three, four, five, six, maybe seven tries, right? The other piece is to think about that sellers today, so a lot of them are going to need a post closing for a lot of reasons.
Mhm.
One, the obvious one right now is weather, right? So they want to get their property sold, but at the same time, we got weather constraints in certain parts of the country, whether they're selling in Colorado and relocating or they're just relocating in Colorado, right? The other thing is, for some of those sellers, they need to sell their home to qualify to buy another one. So they
Right.
need a little time, especially if they're going to be a contingent offer. So yesterday afternoon, I was working with an agent and working on an offer for a buyer, and they're going to put in, I think, 35 days post closing on this offer. And actually, it's not going to be above the list price. There's a couple of competing offers, but those individuals are trying to do quick closes. But when we talked to the realtor on the other side of the transaction, what was really more important was the timing, right? And
Mhm.
these people coincidentally are having a house built, and there was a delay, but now it'll be finished by the end of March. So if we can get it closed in February, which is realistic, give them a 35-day post closing, all the dates should just line up for everybody, right? So it was, I think thinking about that strategy is huge, right? And thinking about the needs of all parties.
Right.
Being
And I,
said, you got me thinking about, you hosted a mastermind last week, and you were very articulate with regard to a number of things that have changed within rentals. And so I was maybe hoping today you could give us kind of a rundown and your thoughts on those.
Definitely, yeah. And again, I think a lot of things. There's been some major shifts, and there's some considerations that um, both that landlords need to take in mind now when they think about acquiring an investment property out here. And I mean, I'm speaking more directly to the kind of smaller, for lack of a better word here, mom and pop style landlord at this point, right? The people out there that are the Gray Stars and the Lincolns and the Windsors of the world are, they have lawyers who they pay a rare amount of money to, they're going to give them advice. So listen to those folks out there. But for our folks out there who do have who are going to consider like, hey, do I want to consider buying a holding on this property when I buy new and investing, right? Do I want to do some sort of a home equity line of credit, or hold on to my current property as I go buy another one? It's important to think about what your responsibilities are and how those have shifted. And if you are a leasee out there, it's important to think about how these changes impact your rights as well. And and again, there's been some major shifts here in Colorado. Like a lot of states out there in the country, is trying to make sure that we are representing people who are on leases, renters out there, but also try to find the balance of making sure that landlords are able to retain their property rights and do what they can with it. And there's plenty of states who are trying to toggle that, and there's some that are very, very landlord friendly, and there's some that are very, very rentor friendly, sorry. And in a perfect world, we'd find a good happy medium. But as always, as things shift, we're kind of have a little bit of a pendulum. And if you're asking for my opinion in this case, I do think we have, on balance, swung, perhaps, I think one could argue, a little too far out of the landlord's favor here, right? Now, that said, I do think that it's important to understand that there's plenty of people who own properties that were bad actors out there, and they need to be called to task for it. And this is exactly what I said to call last week, is if every landlord treated every tenant with respect and put a good quality product out there, we wouldn't need these rules, right? So they don't make them for no reason, right? They're not going to waste the ink to print the paper and to kind of spend their political capital to put these laws out there if they weren't required, right? So as we go through some of these, I'm sure you guys have your own opinions. Please do share them in the comments of the video here, or feel free to reach out to us. I'd be happy to have a discussion, because I'm sure there's things I try to consider everyone, but I'm sure there's things I'm not considering when I'm forming my opinions here. I'm not going to go through this full exhaustive list here, because there is quite a bit of change both at the city and state level and at the House and Senate level that have impacted this, right? So one thing that I do want to point out here, and this is old news, so if your clients aren't aware of this, it's probably past time they should have known about this. But now, as of January 1st of this year, in the city of Denver, every single person who owns a rental property, whether it's Gray starting to manage 130 communities and probably 10,000 doors, you need to have a license to rent your property, right? If you own one single unit, one single door, you need to have a license with the city of Denver to maintain that property. There is a fairly easy portal. We can pretty easily put the link in the comments of this video, so you guys can follow that. It will walk you the process of applying for that license. Pretty straightforward. The one thing you do need to make sure you do as part of that process is, if you want to take it in yourself, fine. If you want to form an LLC, have that information prepared. But you do have to have your property inspected by a city-approved inspector to do rentals. It is not going to be as invasive as the property inspection you probably saw when you bought the property, or that you may run into if you're listing your property. But it is going to check to make sure you have proper fire alarms and carbon monoxide detectors. It's going to make sure you have a fire extinguisher. It's going to make sure that you have like just safety issues that are high level, that are pretty standard for what we expect, right? Does your heater work? Does your water flow correctly? That kind of a thing, right? Do your appliances function? Once you have, so you can schedule it, you'll schedule that inspection. If you have some things that aren't up to snuff, you can get pretty reliably, I know through Axiom Inspections, who's done a lot of inspections for both of us, Michael, they will come back and re-inspect for free a second time to ensure that you've met the checklist. Once you have that bill of health, go apply, and you are licensed now. So that, at this point in time, is just the city of Denver. But from talking to some folks that I believe are in the know on that space, look for that to be statewide in the pretty darn near future. I don't know for sure this year. Maybe Colorado has other things to worry about in an election year, but very, very soon. So that's the city of Denver, a shift that's been happening for a while. It's already been in place for kind of the people who own 4 or more properties, but now every single landlord in the city of Denver has to have that. Now, as far as what we're looking at the state level, there's been a lot of increases in requirements built around what's being put out there as like public health and public safety, particularly around things like radon, as a for instance, right? So, and this is one of those things that I find to be a little silly. I do believe radon should be mitigated if it's a problem, and I personally think this is one circumstance where the state could have done more, right? They could have said like, hey, you are a renter now. You have to test radon. If your radon is at a level that needs to be mitigated, you got to spend your $1,000 and put in your radon mitigation system and be done, right? And then maybe you have to test once every 5 years or something like that, right? If they don't pay the right laws, but I would have considered something like that. At this point, the literal rule is you have to provide a prospective tenant with a pamphlet that says radon exists, and if you have tested or have knowledge about radon recently, you have to provide them with those test results. Doesn't really do much, right? It's kind of similar to what we see on the buying and selling side with lead-based paint, except it's for every single home because homes don't stop having radon gas unless you mitigate it. I find the whole thing kind of silly, but it is a lot. It's important to know that as a landlord and important to know your rights as a tenant. So if you are scared of radon, like if you are a person who has maybe a more maybe more likely to be affected by something like that, like if you are an older person, a person who's more prolonged to sicknesses, or if you have children, that are going to be sleeping in particularly a basement space, then I would encourage you to think about getting some testing done. It can be done fairly inexpensive, probably cost you in the neighborhood of 100 to 120 bucks. I know that's not nothing if you're renting, especially on top of a rental application fee and things like that. But for the peace of mind, if you were going to particularly put like an older person, a more health conscious person, or particularly children in a basement sleeping space in particular that is not currently mitigated, you may want to consider having testing done. I know what's your advice on that generally, Michael?
Yeah, it was interesting. I was just taking some notes here as you were talking. You're right. And radon is lot or parcel specific. We could have a high radon number, but the neighbor next door does not. It's really kind of weird, right? It's interesting what you're talking about is around putting some guardrails around it, right? Like, so for example, if it was you're renting a property, it's an unfinished basement. Well, if it has radon or not, I mean, does it really matter? That's kind of a question.
Yeah,
And
that's not a living space in that scenario,
right.
right?
If the
So
sleeping rooms are on the second floor, in some cases the third floor, does it really matter, right? There's kind of that whole conversation. Now, I am with you if you've got a fully finished basement, you got sleeping rooms, and that was part of the appeal for like having a larger square footage, more living space. You're gonna have people down there living down there. Yeah, I can understand that piece of it. But I do think you're right as far as some guidance that was given. The other piece is on for the license, is that license for the city in Denver as well as the inspection, are both of those annual?
so the answer is it depends. So the license, I believe, lasts for 5 years. So don't quote me on that. I need to re-educate myself. I've been kind of dumping a lot of information in my head on the new state laws, so I probably have filled up my capacity to a certain extent. But I believe it's every 5 years. And now annually, you are meant to have 10% of your properties inspected.
Okay.
So for like the gray stars in the world who own, let's say you own 100, you have to have 10 inspected every year, right? So you're probably going to rotate those through as people, don't renew or as you do not renew them, which we can talk about that in a second. And all that process goes forward, right? But again, I think that likely, I believe I don't think you can do that every single year if you only own one property, because you would likely run into scheduling issues with your tenant and all that good stuff. But I would say to stay on top of it and stay. The website we're going to link it below will have all those details in there. So I guess my answer, I don't 100% know that. I don't want to speak out of turn. But I believe the license lasts 5 years. As far as how often you have to inspect, like if you own one property, for instance, I believe the inspection also mirrors that time, like 3 years, something like that. But I could be wrong, and of course they could adjust the requirements too as they go along. But if you own more than one, or more than four, you are meant to have them 10% inspected every single year.
More than four. Okay, perfect. And then, so you were going to kind of get into some rules around, I guess, deposits and rents
Yep.
and evictions and whatnot.
Correct. So speaking about evictions, so there is a law that passed through the House of Colorado, and these are all laws that have passed the House and the state, or the Senate, apologize, in the state of Colorado, and been signed into law by Governor Polis. So I don't believe they were all housing related. I'm sure they weren't actually, but there were several things that passed through both of the government and then were not signed by Polis, were vetoed instead. And so keep that in mind as more things come through. Who knows what's going to happen, right? But there's an eviction protection law in place. Particularly now, this applies to people who are receiving some sort of assistance, right? So particularly if you were on supplemental Social Security income, Social Security disability insurance, or through the Colorado Works program. So if you're receiving money from the federal or state government, I would say it's important for you to understand the sourcing of that money and where it comes from, because you may have more rights than an average Colorado renter that's not getting those sorts of benefits. So now it is primarily on you to know that, right? Like, because we don't have because another law we'll talk about here in a second that's been in place for a while now is you cannot discriminate on source of income. While like some landlords may know you're receiving, a Colorado Works program benefit, some may not. It's really on you to know that, right? Um, but so normal people who are not experiencing or not receiving those benefits, if you do not pay your rent, you can get a 10-day notice to vacate, right? Or after you have that for 10 days, they will say like, hey, we're going to start the eviction process. Now, that all does take time, so you have to go through and have a court date scheduled and then receive a judgment and then have someone come take and then someone come serve you an actual invention. A sheriff will come and take care of that process. That does all take time, right? However, if you're receiving those benefits, two things happen. That goes from, instead of being a 10-day notice to being a 30-day notice, right? And you were also entitled to a mediation process. And that is at the expense of the landlord. So basically, or I'm sorry, so any of those benefits are you get the required mediation. If you're receiving money from the Federal CARES Act is when you get the 30-day eviction notice as opposed to the 10-day eviction notice. So I apologize. But just keep that in mind. So if you're receiving a benefit, you would likely or do mediation between yourself and the landlord. So it doesn't mean they're going to wipe away your tenants, past due fees in rent, and landlords, and renters doesn't mean you cannot pay rent, right? It just means that there's an extra step of mediation required in there before the eviction process can go forward. Okay. So they wrote that the idea behind this is to protect people who are likely the most vulnerable to something like that, right? So an eviction process going forward. And whether or not like the government assistance program you're on like steps in and helps to bridge the gap there. Or I mean, like I'm sure there's a world where a tenant just didn't fulfill their responsibilities and the mediator's probably like, dude, you didn't pay your rent. So anything in there between there can happen. I'm not going to pretend to have insight into what every individual mediation process goes, but you are entitled to mediation if you're receiving government assistance. And additionally, if you were receiving money from the Federal CARES Act, which that money's probably really darn close to dried up if not done yet. You are entitled to a 30-day notice for eviction instead of a 10-day notice to eviction, like most people are here in the state of Colorado.
And that would include, so, clearly if there's a unit available and we own an income producing property, we're going to have, through the application process, some of these questions are going to have to now be on there to know that, obviously, right?
Well, right, but you also at the same time, so you cannot discriminate against someone for their source of income. So if you and I apply and our qualifications are similar, right? We'll talk about the rental requirements for income here in a second. And you cannot discriminate against me because I am receiving money from the Colorado Works program in Social Security, let's say,
Right.
and you who are a business owner and you make your money differently, right? So wherever the money comes, the money is supposed to be money to a landlord, right? So you can't really discriminate against that. So
Right.
if and again now how like the likelihood of me pursuing a landlord for discriminating against me in that case, would the visibility may be tough, but could I do it if I wanted to? And I found out they ran into you instead of me and we had similar qualifications, I could, right? So
Yeah.
where that goes is up to judges and juries and people we don't have insight into, but this is just kind of laying out there what the requirements are.
So then could there be a scenario, and maybe it's too early to tell, but could there be a scenario where, the landlord, you do everything right, and then somewhere from the time that they moved in and took occupancy,
Mhm.
moving forward, something has happened and now they're on government assistance of some level, whatever that level is, right? Or because it happened post, the landlord wouldn't know about that, right?
Sure.
So does the tenant have an obligation? Do they need to explain to their landlord that this happened? And hey, now I'm on government assistance of some level, whatever it is, but it doesn't change our lease at this point, just so you know.
I mean, I don't know. My gut would say no, you
See that
know.
happen, right?
My gut would say not until it benefits me, right? So, like because similarly, so like I have this job now. If I lost this job or got a different job, and as long as I pay my rent, I'm not obligated to tell my landlord I had a job change, right? and I'm not typically obligated to like re-qualify, though if you are on some government programs, you are qualified to recertify. But not with my landlord. That's with my, person providing me the benefit. Now, if I fell behind on my rent and I got qualified for one of these cash programs, and someone served me a notice to pay my rent, like a notice I was being evicted, then I could I activate my benefit? I would imagine so, right? So I don't think you would obligated to let them know, but if you did fall in hard times or lost your job, you're not qualifying for a benefit, and you were unable to meet your burden, could you take advantage of that? Probably. Now, from a more practical perspective, is it maybe more advisable if you know the rent's going to be a problem, even with your benefit? Because that's a real issue that a lot of people run into, man. Colorado wide, but Denver in particular has expensive rent. And there's if you are a individual human being, there's only so much benefit you can qualify for. So if those numbers don't match, is it maybe better to have a blunt conversation with your leaseholder and say like, hey, here's the situation I'm in. Can we navigate this in a way that works for both of us? I would say I would probably start there, because it doesn't hurt you, to your point, to let your person know, because until you fail to meet your burden, they can't like start the eviction process, right? Like if I lost my job tomorrow,
Right.
my landlord can't evict me on that grounds, right?
Exactly.
Until
Exactly.
I don't pay rent or until I have a noise violation or something, right? Until I have a lease break, they can't. Yeah, we have a lease, man. Does so again? That's another word. It doesn't matter where the money comes from. If I found a bag of money on the street that was a year's worth of rent, I should report that to the police. But theoretically, I could pay. I could pay my rent for that time, right?
As long as you meet your obligation, it doesn't matter where it comes from.
Right.
Okay. So you're going to talk a little bit about the income and source of income here next.
Correct. So there's a couple things to keep in place here. So, and again, I've worked in rentals for a long time, and transparently, I didn't know if there was like a particular rule around when one could use for income requirements. It seemed like it was kind of up to the individual landlord, the individual entity that was either managing the property or approving the rentor if it's an individually owned price. But in my experience, in general, most like especially like institutional landlords, again, think about your Graystars and your Lincolns and your big management companies of the world. In general, I saw them typically requiring somewhere between 2.5 to 3 times the monthly rent as gross net income or gross monthly income. So it would be rare, and again, I don't know if it ever really happened that at least at that level that someone would go through the process like you would go through when you're buying a house, where they're going to say like, hey, you might make 100 grand a year. That's all well and good, but are you shelling out 90 grand a year in financial responsibilities, right? So I I don't know that was like part of the requirement before, but now the stated amount is so income requirements for tenant cannot exceed 200% or 2 times rental amount, and the landlord cannot be allowed to use that information about income except to verify the income makes over 200% of annual rent, right? So basically that's saying that like you can't say that, yeah, Andrew, you make XYZ dollars, but your output is also ABC dollars, right? And so you can't do the math there. So that's all we need to do, right? So, and another thing to think about here is if you are um have housing assistance or are seeking housing assistance, that's all they can use is that 2% or that 2 times the monthly rent, right? So if the tenant's seeking housing assistance, the landlord cannot use a credit score, lack of credit score, or any adverse credit events like late payments unless it is federally required for them to do so. Um, so if the landlord is statutorily required to use a credit score, landlords cannot consider information more than 7 years old. So that would be like if you were had a house that qualified for like Section 8 or something like that, right? So now there is a difference between this is probably getting too far in the weeds, so I'm not going to dig in too far, but there's a difference between Section 8 rental and a person who's qualified for Section 8 that can take that money and use it anywhere, which is the same case in Colorado. So like I can use my Section 8 dollars wherever I want to, but if I have a Section 8 rental, they're built to have lower rents. So my likelihood of me being able to qualify is increased, right? Or have my burden covered, right? So I don't have to couple with XYZ dollars, right? So because I don't qualify for an individual home necessarily, I qualify for XYZ dollars based upon my income and how many people I am. So the state of Colorado is going to give me ABC dollars. So Section 8 housing is in general, and low income housing in general is built to be about that cost, right? Give or take, versus like a standard single bed, 1 bedroom house or 1 bedroom rental in Denver is going to capture the maximum they can. And so I'm only going to get a check from the state of Colorado or the federal government for ABC, and they may not align, right? And then if I can bridge that gap, then maybe not right away, but the likelihood of someone from the state of the or the federal government saying like, "Hey, man, where's the extra money coming from?" is probably going to be in there, right? So they typically do work hand in glove, right? So that's what it's saying there is if you were required as a landlord of a house, of a property that has specific requirements from the federal government to ensure their income is ABC, all you can do is make sure that their um, income lines up. You can't really consider their credit score, and you certainly can't consider their credit score if it's more than 7 years old. So if you had, some sort of issue with a car getting repossessed 8 years ago, doesn't matter, right? So,
That's interesting.
um,
I had a rental that that I had on the Section 8 program out there in Arapahoe County,
mhm.
and I got to be honest with you, it was slick. It was super slick. I mean, it was granted the monthly rent was not what the normal market would be if it on the open market, but working with the county and the state is the first day, the first business day of the month, that direct deposit never failed, right? And
Not everyone has that experience
yeah,
that's managing those properties, I will say, but the money
exactly.
does come eventually. So,
Right, right.
so
So now, fortunately, I was very, very fortunate and very blessed in the people that we had in there. Um, and it did have to get re-inspected by someone at the county every year.
mhm.
They required, actually, I'm sorry, they required it every other year. And they also uh, had statement from the tenant to just to ensure like what you just said, like, hey, if the rent, if it's $1,300, that's what they're approved at, but the going rent is $1,900. Hey, but they're paying me that money, and how they find it is they find it with your tax returns,
Right.
right? You show all that income, they're going, oh, wait a second here, you should have only showed X, right? But you're showing this, then they go back. So, but for me, it actually worked out really, really well. Walk through just a quick example. Take your single family detached 3 bedroom, 2 bath house that would walk us through how that 2.5 or 3%, or that 2 times the rental amount or 200%, kind of walk that through what that would look like as an example.
Okay, so I'm just going to finish up two things here before we move into that because
Okay.
it's it'll
Yeah.
all be here. So we talked about kind of that process of application, what that looks like for someone who is currently receiving or in pursuit of some sort of benefit, right? Now, if the tenant is not seeking housing assistance, the landlord can use the credit score as a means of selecting a renter, right? The any landlord, even if they are someone is pursuing or is in possession of housing assistance, can require a positive rental reference, right? So you can make sure someone has the ability to like generate someone saying, "Hey, I've rented from this person. They said I was a good landlord." And then a security deposit cannot exceed 2 times the monthly rent. So that's the last thing to think about there. So I guess so if you are a landlord, you were renting out your house in Inglewood, right? And you get some applications in, you get an application from this family. And there is so you can require an application. Now there is something we'll talk about here in a second, where there is kind of a sort of a standard the essentially amounts to like a standard application that every landlord in Colorado is now required to accept, right? If they have that and provide that to you, you do have to use it, and you cannot require further applications from there. Now there are companies out there. My Smart Move is one that's commonly used. You'll get kind of standard applications through Zillow if your home is listed on there that you can require someone to fill out if they do not provide you with that tenant form. So in general, it's going to ask for now. Some of them may or may not, like my Smart Move does not provide you like their credit scores, as a for instance, but it gives you like a rating system based upon their credit, their income, and their general output. It says, hey, this client's going to score a 600 or whatever, right? It's kind of a weird, complicated proprietary thing, but it gives you an idea, right? And it'll tell you how much they make per month and how that aligns with their rent. So uh, basically, if you see that hey, your rent for your house is $3,000 a month, right? And they make $6,000 or more, you cannot use their income as the reason why you were not going to approve them, right? Um, Now, what I guess remains a little untested would be like if I am that person and if and then I have someone else who applies to the house and they make $8,000 a month, can you differentiate that way? My gut says probably not. At least I wouldn't. It's probably not can't be like your stated reason for disapproving of someone. I don't know. It's a little untested. Now, I'm kind of basing this off of what most, again, institutional landlords are going to do. And they are like, they're going to take the first qualified applicant. right? So the first person who passes a credit in if they're not using housing assistance, criminal and rental background check that has 2 times a monthly rent, they're just gonna take that person because they don't want to put themselves in a position where they might be exposed to some sort of legal liability, right? Individual people are going to make their individual decisions. So if you were like, hey, my landlord, I got 10 applications this weekend. I'm gonna look at them and pick the one I like the best. I mean, you may be okay, you may get sued, you may not. It's hard to say, right? But the most conservative way to do it is to say like, hey, I got an application. I'm gonna take it off the market until I can see this person's qualifications, right? I want to get their confirmation of their rental, of their income, right? I want pay stubs or an offer letter or something like that, right? When I see their credit score come back, if they're not applying for assistance or currently have assistance, and I want to wait for the criminal background check to come back. And if they don't have like a felony or something like that, they don't have if they have like clear criminal history, their income is above 2%, and they're not, or 2 times, sorry, and they're applying for assistance or can have assistance, you may have to say like, hey, this person's meets my qualifications. If they don't and their credit score is 500, you can say no, you know. But if their credit score is 720, and then you get an application the next day, it's got a little more money as far as income's concerned, it may be a tough argument to make that you didn't use not their income as the deciding factor. So again, we don't know what happens. We put things in front of judges and juries and things like that, but that's kind of the lay of the land here as far as like the application process is concerned. Does that make sense? What I'm saying?
Yeah, no, it does. I think you framed it really, really well, and I think this stuff is new. So you're going to have a percentage of people out there that aren't even aware of it. You're also going to have people that are aware of it, and then you're going to have people that do their own thing. So you're right, and until it gets challenged, that's when some of this will happen. One of the things that we talked to our agents about last week was we all have clients that own income producing properties of some level, right? Whether they're actual long term or if they're short term, which I know is handled a little bit differently. But more importantly, this is another great reason to stay in front of your database in your sphere. If nothing else, just have a nice hit sheet of, hey, did you know? Were you aware? Right?
Mhm.
Especially for those that own property in Colorado that don't live in Colorado. And there's a lot of those out there. They moved through the pandemic, but they kept their property, right? But they're not there, too. So I think that what a great service to offer those individuals of, here's the framework, let's talk about it. And if we need to get some counsel, we can get you some counsel, right?
Exactly. So if a person were to be found to be in violation of those application laws, the landlord that violates new application requirements would have to pay $50 to the prospective tenant, and if they don't fix the issue, would be subject to an additional fine of $2,500 paid to the tenant.
How much?
50 for sure, and then if the issue is not repaired, an additional 2,500 that goes back to the tenant.
Dang.
Yeah, they're not messing around, man. So again, it's just think about the kind of things again, and then these obviously are brand new, so probably a little bit untested. But I don't know that I want to be the guy to test them. So like, and then I know we talked briefly about this, that like uh, generalized application. So it's called the Portable Tenant Screening Report. So it's a consumer report that will be prepared at the request of the prospective tenant that includes the following information that's provided by a consumer reporting agency. So it must be current, which is defined as being less than 30 days old. It must have the tenant's name, their contact information, their verification of their current employment and their income, and it must include their last known address. So if you notice, credit is not on there. So basically, when the advertising the available unit, you have to disclose in 12-point bold-faced font. Again, this is the wording of the law. So again, I think it gets pretty pretty like small here. But you have to disclose this in 12-point bold font. The tenant has the right to provide the landlord with a portable tenant screen report, and if that is provided, the landlord is prohibited from charging additional application fee or charging a fee to access or use the portable tenant screen report. So, yeah, there you go. So you're
So having a standardized application actually could probably be a good thing across the board versus those people that we all know them. They knew somebody who knew somebody. Next thing you know, they're renting a place and all they did was sign a lease. There was never an application. and that happens all the time. So I think that's going to probably stop. It's going to have to stop, right? It's no different than a job. I mean, it's no different than if you had a W-2 job, your resume is one thing, your interview is one thing, your presentation's one thing, but at some point you have to fill out an actual application with a wet signature at some point, right?
Right. It just,
But
I could see, some in my experience, some landlords are really cognizant of what uh applications or a person applying for their rentals credit score is, I mean, but that's not the only thing that's left off of there, right? Like that doesn't say that you have to guarantee that person's like free of having been evicted, right? There's, that doesn't address the criminal aspect they did right there. And again, this is me reading this, and I don't again know how this will be tested. It says if the tenant provides the portable tenant screening report, the landlord is prohibited from charging a rental application fee or charging a fee for access to use of them or the portable tenant screening report. It does not say you can't require them to fill it out and you pay for it, right? So again, might be a conversation worth us taking to the next level and talking to a particular a legal expert lawyer that surrounds this report. I think that would the way I read that again this is just kind of the bullet points here, so it's not like the actual statute. I would think that would probably be okay, right? Because I mean, there's certain instances where you might be putting a tenant, and again, this is probably not the smartest thing to say on YouTube, but like, let's say there was a world where I owned a rental and, there was a person who was required to register as a certain type of offender. And they provided me that and I did not pay for, and I did not do an extra check. Does that put me in violation if that person's in like a housing community or a condo community or something like that, So, just be cognizant of it. Again, that doesn't necessarily mean you can't do it or you shouldn't do it, or in certain cases you're not required to do it. It just means that you cannot charge the rentor for those. Now, it's been my experience that most of those things are pretty inexpensive, like I think it's, like 40, $50 right in that ballpark in general, through like My Smart Move, and there you could probably shop around and find them less expensive. And you're not allowed to profit on those anyway by state law. So like you can't charge me $75 for a rental fee that costs you $50, that would be illegal, and that they do not like that. So, so state of Colorado doesn't like that at all. Just keep that in mind. And again, now this is for a person who goes out there and like pursues this, right? So they're transparently, in my experience, kind of tough to find like that official service somewhere where they can provide you with that portable tenant screening report. Now, will it get better? I'm sure there's money to be made for the right background check company to provide that to tenants. So just keep that in mind. And will there be like a supplemental, solution for landlords that's not as expensive as a full background check because you're getting a lot of the information from this? I don't know. But all I know is that you are not allowed to charge the tenant for additional background or for additional screening if they provide you the portable tenant report.
it's wow, it's a lot. It's a lot, right?
Well,
I'm
and
just
again, and
I'm
again,
just
this is just things to consider if you are currently a landlord, just to make sure you're aware of, right? So your responsibilities increased and your costs probably been up a little bit, and some of your ability to screen for tenancy probably got reduced a little bit, right? Now, again, this doesn't, I'm not to say this is right or wrong, or I don't really have a dog in this race. I owe my duty to the public, and my duty right now is to inform landlords and renters of their rights and responsibilities. And then they can make their own decisions about what they want to do with, if they're a landlord, what they want to do with the rentals beyond that and how they want to handle it, right? But I'm certainly going to advise you right now, do not try to skirt these. Just if you're going to do it, follow the rules, man, they will figure it out eventually, probably,
I'm just waiting for a day. I mean, do you see a day where there's going to be a rating review agency or public portal that rates landlords?
Oh, I mean, I think you're fooling yourself. That's not out there already. I mean, I mean, Google, Yelp, like it's
I was just
would there be
thinking,
like a rate my professor for them, maybe if there's not already,
right.
So yeah.
I was just thinking about, on the short-term rental world, right? Not only do, does the user, right? They rent their experience and rate this, that, and the other, but also, people that own those properties, they actually have a rating or a review against the tenant as well.
Yeah,
You know,
those are, I mean, and my wife and I, we commonly stay at those kinds of things. And it's
yeah,
actually, so you cannot see the other person's rating of yourself until you actually, after you submit yours. So it's kind of interesting
yeah,
how
yeah,
that works
yeah.
out.
It's kind of interesting. Like I noticed that on the last Uber ride, the Uber driver can also rate you as a rider, just like you rate them. We're in this shared society now. too, where there's so much more and more transparency, right?
Yeah.
But you're right. I think there's a lot kind of going on there. So wow. Well, any other final thoughts on that as we move forward?
I mean, this is getting long, but there are two more sections here we could cover. We can also save these for next week too. These will be this probably is a good breaking point. And this is getting long, guys.
Yeah.
So we'll come back to this next week, but
Okay, let's
next
do
week
that.
we'll discuss some actual prohibited clauses in leases going forward,
Okay.
as well as one's ability to how one's allowed to restrict pets or lack thereof
Oh, that's a big
uh,
one.
going forward too. And again, guys, whether this stops here, whether this continue, I mean, if we follow the track of how the political leanings as far as rentals are concerned in Colorado, I could see potentially more things being added in. I could see that this talks about how much one can charge for pet rent or pet deposits. I could see restrictions on how one can restrict pets being instilled.
Yeah.
Um, there was kind of a heavy hitter that we discussed last year, Michael, as far as how one has to navigate no fault evictions, right? So every time someone doesn't terminate their lease themselves, every time I say, hey, I don't want to continue living here. Strictly speaking, that's an eviction, right? Now, again, we don't like report those to your credit agency or things like that. But like, if Michael, I was renting from you, and I had a 1 year lease, and per our lease agreement, there was a 60-day notice to vacate, and you said, hey, on day 90 days out from my lease term, my lease ending, you said, hey, Andrew, we're just not going to renew you. Go ahead and find another place to live. That is called a no fault eviction, right? So I did not pay my rent. I didn't violate any lease terms. You just don't want to rent to me anymore, and that could be 1,000. It could be that you don't want to rent to me anymore. Like I didn't violate any leases, but maybe I was a little noisy, or maybe you didn't like the way I kept certain things, and or whatever the case is, or maybe you want to move into it, or your sister, cousin, brother, daughter, aunt,
I
uncle
was
wanted
gonna
to move into
say,
it.
yeah.
There, maybe you wanted to sell it, right? And you didn't want to sell it with a tenant in place. So those are various levels of no fault evictions. So something was proposed and it didn't make out of committee. Though my understanding it was very, very close. And if it did make out of committee, it might have had the votes. Again, this is me going off of
Yeah.
someone saying something. I don't, they don't let me vote in the Senate of Colorado yet. But that's my understanding, right? So what this would have done is it would have said if you were to be the recipient of a no fault eviction, or if you were to provide a no fault eviction to someone as a landlord, let's say, the landlord were responsible to provide 2 months of rent to that person as a rehoming fee, unless they were happen to have someone who was, I believe it's under 18 or over 65, or was receiving public benefits to a certain extent, and then that would jump to 3 months. So again, I that's my understanding. If the wording was a little bit different, or some of those responsibilities changed a little bit, I'm happy to hear you guys out. But that was my understanding. So does something like that come back in some form? And again, and you also couldn't really adjust the lease. So like I said, if you didn't like the way I kept the grass, like if you did your original lease didn't have the HOA considerations in there, or if the HOA laws changed, or if you were getting some plays from the neighbor that I was being a little bit noisy on the weekends, and you didn't have like a hey, quiet hours are at XYZ PM, which we can talk about whether or not that's good language too next time. Then you have to provide me a largely identical lease with, I think the language of the proposal was a reasonable rent increase. There's yeah, then you would be fault at for a no fault evicting me, it would owe me some money. So again, that's nothing that's printed yet, but that's was kind of the general idea about what was proposed and didn't make it through committee, but doesn't make it this time, right? Does add a political pressure of an election year make people who are pushing back against that a little more resident do so? Who
Right.
knows? But again, things are shifting. They're swinging pretty heavily in favor of renters, which again, I'm happy with renters' rights, but just want to make sure that renters know what their rights are, landlords know what their responsibilities are. If you guys have any questions about how to handle this, I'm happy to, provide you with the specific House and state bill that we have spoke about here that you can, provide to your lawyers, or we can discuss different strategies on how you may want to, like, perhaps think about withdrawing your rentals in Colorado and maybe pursuing them in a different state. Who knows? Why are there fireworks behind me?
You get fired. It's kind of
But
crazy.
just keep that in mind, guys. But yeah, going forward, we're happy to answer any questions. And yeah, I guess we'll dig into it next time, a little more of what the lease restrictions are, as well as what the pet expenses can be, and kind of go from there. But it's a big meaty topic, guys. It was a
Yeah.
big subject of our licensure requirement this year. So I don't think they're going anywhere. So just keep that in mind. Yeah.
Well, really good summary. So if you send over that a couple of those links. We'll put them in the body of this YouTube video. And then I think for our next one, you're right. We'll kind of maybe pick up where we left off. And then we've got a couple things coming up. We've got a happy hour coming up, or mixer. I guess we call it a mixer at our office on Thursday, February 1st in the afternoon.
Yep.
And then I know you're working with some industry partners as well to maybe put together a class on some of this stuff as well.
Yeah, to make it a little more concise and more fun, hopefully, as fun as talking about
Yeah,
state laws can be.
yeah,
But I think it's just important that we as industry professionals, realtors, title companies, lenders, even lenders to a certain extent, should know about this. But certainly, I feel an obligation to let my clients know that who currently own properties or who are thinking about going into rentals know what their responsibilities are, because man, the last thing would have happened is someone think that, not be aware of some of these responsibilities and then get sued and be in a really tight spot. And that's transparently, I think it's going to happen, unfortunately, right? I think there's people who maybe are new to rentals or maybe have owned the rentals for a long time and just don't stay up to date on some of these new laws that are passing, and maybe don't have access to a real estate professional that's going to keep them informed of them. And unfortunately, they're going to maybe be pursued legally, right? So, and again, hey man, the laws are the laws. It's our obligation to be aware of them and our obligation to follow them. But it's also a really nice thing we can do for our clients is to inform them of what the current landscape is, what the current laws are, and help them to the best of our ability, either get in alignment with them, or if they want to move on, then help them do that too, right? It's always their choice. We're here to help.
right. It's interesting. There's all these different classifications of landlords, right? You've got those that purchase these properties specifically, from a portfolio perspective. You've got the
Mhm.
large companies, you got the individuals. I remember years ago, young Michael and Stephanie. This is 20 plus years ago, maybe 25 years ago now. We each had our own homes. We didn't know each other, and when we had met and we blended households, we bought a home together, which we lived in for 12 or 14 years. But one of the deals we did at the time was we said, even in our offer, that we had gave ourselves 10 days or 15, I can't remember what it was, to get our properties rented. If we couldn't get them rented, then we would be able to back out at the time. But there's a lot of people that are accidental landlords. They fall into this stuff, right? And
Yeah,
they didn't go out and seek this, and so they don't know. They're focused on their next thing, right? But again, to inform the public, to protect the consumer, and to protect our clients. I mean, this is exactly what we do every day, right? This is another level now of, if we can start to get this expertise here, hopefully we can guide our clients through a lot of this and make being a property owner a positive experience versus a negative.
exactly. And again, it's here to inform. I'm not here to encourage anyone to do anything with their individual properties, man. But your responsibilities are what they are, and if we can help you get into alignment, man, we have no shortage of people we can refer to that can do those rental property inspections.
Oh yeah,
We have
yeah.
no shortage of people that can help you do some testing and even some mitigation for a radon if you want to, right? We have no shortage of people who can help you with a great lease. We are blessed to work with a really, really talented and very fair-minded real estate attorney that can help you write a really rock solid lease that's going to protect you and the renter, right? But at this point, it's our job to inform and then help you out with whatever way you want to go with it.
That's great. Well, I appreciate that. Well, I appreciate everybody for listening to us, or if you're on YouTube, that's amazing. Be looking forward to the next series in this, maybe next Friday or the Friday after, one of the two. But until then, have an awesome week. Everybody stays warm out there.
So, you guys have a good one.
All right, peace.